Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It's been nearly a year since July 2nd, 2025, when, to the surprise of many people, Brian C. Kohberger stood up in open court and pled guilty to 5 very serious charges that he was about to stand trial for in the high-profile case of Idaho versus Kohberger, a case that was largely sealed from the public, that after Mr. Kohberger pled guilty, the media coalition filed a motion to unseal the case, which Judge Hippler denied, announcing a process that he would go through, starting from the end of the case and working backwards, and determining if the large number of documents under seal from the public should remain sealed or should be unsealed. Judge Hippler, for all intents and purposes, stopped that process several months ago. There are still 89 documents for the months of January, February, and March of 2025 that he ordered to be unsealed that are still sealed to the public. And so questions linger as to what exactly was the evidence that the state of Idaho had that one person and one person only was responsible for the catastrophic events of November 13th, 2022, and why did the only person who was ever charged with these crimes decide to, what appeared to be, engage in a very different strategy than had been engaged in for the more than 2.5 years that this case was in pretrial, when defense counsel stood up in open court and stated that her client was factually innocent, where both sides battled very aggressively for their respective positions. Only Mr. Kohberger can answer the question of what caused him to change his plea. But in looking at the docket, is there any bit of information in the days and weeks leading up to June 30th, 2025, that was the date that the plea deal was entered into, and the date that Mr. Kohberger, because of that plea deal, waived all of his constitutional rights, including the right to that jury trial. There are 2 court orders that were rendered the afternoon of June 25th, 2025, both of which were unfavorable to Mr. Kohberger, were substantial. Could one or both of those rulings have played any role in his decision to not go to trial? One of those court orders of the afternoon of June 25th, 2025, denied Mr. Kohberger's intention to raise the defense of alternate perpetrators. He had identified 4 alternate perpetrators, and if allowed to raise that defense, would have been able to introduce evidence at trial and argue that someone else was responsible for the crime. The defense was denied that opportunity because Judge Hippler agreed with the state that Mr. Kohberger had not raised enough to meet the legal standard under a Supreme Court of Idaho case called State versus Meister to do so. The second order denied Mr. Kohberger's motion to adjourn the trial because of extensive and negative pretrial publicity. That was one of the reasons that was raised in the motion to continue the trial. The second was that there was still outstanding discovery, and this was a matter that the defense raised for many months and years, that it did not have all of the discovery necessary to defend itself in the case, or that the discovery was sent in a manner in which made it difficult, if not impossible, to ascertain what was relevant and what was not to Mr. Kohberger's defense. That was also denied, and so the rhetorical question is, did the motion denying the adjournment of the trial and or denying Mr. Koberger's right to raise alternate perpetrators play any role in his decision days later to forego his right to a jury trial and to plead guilty instead. Until next time, this is Kathy. Thank you for joining us here today.